adhered to this time. Caroline B., KTN News.
Now, the ruling by the Supreme Court yesterday has brought a lot of mixed reactions on social media, specifically Twitter. So right now, I'd like us to, have a look at some of the reactions that came out yesterday after that ruling was given. Of course, some Kenyans took to social media to criticize the decision, especially as the ruling came after the country's Minister of Education allowed turbans in schools for students from different religions. Now, we have on the screen, that is the well-known lawyer, that is Ahmed Nasir Abdullahi, who said that today's judgment was referring to yesterday's judgment by the Supreme Court on the hijab was a new law for leadership of Chief Justice David Maraga. If it goes ahead to say that the judgment is inspired by a poisonous evangelical jurisprudence that repudiates the rights of Muslim pupils to wear hijab, the court showed an acceptable degree and of course of Islamophobia, and that is what he had to say. And again, we also have Magunga, who said that so the Rastafarian student can wear dreadlocks, but another Muslim student cannot wear hijab. Remember, the Rastafarian student was blocked from joining Olympic High School because he had a Rasta. So the question that Magunga is asking is why the Rastafarian student was allowed to wear dreadlocks, but another Muslim student cannot wear hijab while in school. Now, we also have, of course, still Ahmed Nasir Abdullahi still, talking about this Supreme Court ruling where he says that the Supreme Court gave a seal of approval to fascist policy that treats Muslim children as second-class citizens who are beyond the reach of the 2010 Constitution. And he says that for a lawyer who has the misfortune of arguing complex or weighty matters before the court, he's least surprised by that decision of the Supreme Court that was given yesterday. We also have Bill Okero, who's remember, he is Honorable Bill Okero says that the Supreme Court hijab ruling, he believes that the court gave a flawed ruling that undermines the provisions of the Constitution. He says there is need to revisit the matter too, and as others have done before. And he finishes by the word Hatu Banduki. All right, those are just some of the reactions that happened yesterday on social media, specifically Twitter. Let's talk to Duncan Okach, a lawyer, just to try and explain to us whether the media misinterpreted the ruling of the Supreme Court and what does it mean to Muslim students. He's joining us via way of phone. Thank you so much, Okachi, for talking to us. What does the ruling mean, especially to Muslim students who wear hijab while in school?
Thank you so much for this call. In my view, I believe that I think the headline of the report, in terms of the headline, may not be as accurate as is expected to be. And that is why we have all this hue and cry, because people are not reading in between the lines in terms of the import of this particular ruling by the Supreme Court. The Supreme Court was very clear in terms of dismissing the position of the Court of Appeal, and in so doing, allowing the appeal by Methodist itself. If you look at it in clear terms, someone will actually presume that the Supreme Court has not agreed in totality with the Court of Appeal. And in that context, it is clear that the Court of Appeal indicated that the rights of these Muslim children, or the rights to religion, should be upheld while people are undergoing schooling. So when it comes to the fact that the Court of Appeal has overturned that decision, the immediate import of it will be that the Court of Appeal has disagreed with the Supreme Court has disagreed with the Court of Appeal on that issue. But the reality of it, when you look at the ruling itself, it is actually very clear that there are other issues that came up. There was an issue over technicality in terms of an averment in a response, which the Court of Appeal understood to be a counterclaim. But the court indicated that that was not a counterclaim, and has indicated clearly that its decision can actually be dealt with still within the confines of the courts, because it was only edged towards specific issues in terms of where a church is sponsoring education and where rules are already made. The import of the Supreme Court decision was that it is the board itself that will make these particular decisions. That is, the schools themselves have the mandate to make decisions in terms of rules, but they never pronounce themselves and said that school uniform or hijab should not be part of school uniforms, or there should not be any exemption. You will not find a word in that particular ruling, which I have read more than 3 times, that says that that hijabs are now prohibited and everyone must wear school uniforms. It only gave powers to the school to make these particular rules, and it is to the confines of what was before it in this specific context. And the Supreme Court judges indicated very clearly that if this question is brought about, because there's still room to bring about the question on these fundamental aspects in terms of freedom of religion as related to the Basic Education Act, if that question is brought about either to the Constitutional Court or the High Court, it goes up to the Court of Appeal, and even to them, they will have a chance of rendering themselves on whether it is constitutional or not to interfere with a Muslim, or let's say the Akorino religion, or anyone whose religion requires that they have a certain dress code. So
I was getting there, Wakili, because the Supreme Court said every school has the right to determine its own dress code. And of course, dress code here, we're talking about our Muslim brothers and our sisters who wear hijab. We have the Akorino who wear the turban. Then the latest case, you also had that one for the Rastafarian. So where does it leave the school exactly when it's making its decision when it comes to school dress code?
You see, the question that was before the Supreme Court was on that right. Does the school itself or the board have the right to make this decision? You see, that's the question as framed. What was being framed now by the respondents, which should have come in as a counterclaim, so that it is a proper question for formulation by the court, was now, does that interfere with the rights of the Muslim students? That question was not properly formed or framed, because it was framed in a reply. It was not framed in terms of what we say a counterclaim or your own suit as against. So it is important and that is what the Supreme Court said. If someone today goes to court, frames this as a question that should be asked by the court, then the court will actually render itself on that. But at this particular point, the question that was before court was, does the school have the right to make these choices in as far as uniforms are concerned? And the answer was in the affirmative. But they never answered and said that you ought to be discriminatory at that particular point, or whether that would be discriminatory on certain religions, because that question was not proper, and that's what the court said. In the Court of Appeal, it was not a proper question because it was not structured by the respondents.
All right,
so
I think
that's why there's room for more litigation. Normally, the Supreme Court is the apex court, but in the ruling itself, they've opened it up to more litigation on that particular question of violation of a constitutional right.
All right, thank you so much, Duncan Okach, a lawyer, just trying to explain to us the Supreme Court's ruling yesterday when it comes to Muslim students wearing hijab in school. Taking us to our first commercial break here on KTN News Center, but we still have a lot lined up for you.